Hi everybody. Hi, I'm Fiona Martin from Martin Searle Solicitors, and this month we've been running a campaign called Disability Matters, and as part of that campaign we did some free training for community works for those organisations so that they would learn how to be fair and efficient employers, particularly around the issue of disability. And out of that, there came some inquiries for lots of people that does employee rep work. And so what I've done is try to change and tailor-make this course so that you can really help your clients as best as you can without, being employment lawyers. So you get them where they need to be. And perhaps, if you have good employers who've just done something that they didn't know was discriminatory, you can make sure that they're listened to and that the things that they're raising are dealt with properly. So I'm aware that at the moment we have 5 organisations here and quite a few people all coming along. So we've got Mind, Southdown Housing, Ezra, the NHS, and also the Carers UK. What would be really good is if you could perhaps have one person from each organisation just to tell me a little bit about what you do with these employees so that I understand and I can not only sort of present this and answer your questions, but try and tailor it to those needs so it's as useful as possible. Sarah is the only person from Ezra. Would you like to tell everyone a little bit about your organisation, what your role is there, and what would be really useful for you to get out of this training?
Yes, my name's Sarah Ferris. I work for an organisation called Ezra, and we are a mental health employment charitable organisation. We're based in Red Hill. My role is as an employment manager to support people to find work, but we do have many clients who come through to us who are at risk of losing their job due to a mental health issue, whether that is short-term or long-term ongoing. And we have access quite a fair amount of support really and advice from Martin Searle over the years, and Fiona in particular, to give us some guidance with particular cases. So I think today I would really like to find out more about supporting individuals once they have lost their job or been they've left their job, and what the process is after that. I understand you have 3 months to appeal a decision if they've been sorry. Don't
worry. I understand.
A bit of a cold this morning. I'm trying to.
Yeah, don't worry. I understand what you're asking for, and I will.
Thank you.
It's not in the slides, but much. I think one of the things that you all have to be aware of is time limits. They're really, really important. So I will deal with that actually as an additional thing. Would someone like to perhaps speak on behalf of Mind, and perhaps? I know I've had lots of nice questions from the team at Mind, but just tell us a little bit about what you do. What your role is there and what you'd like out of this session.
Thank you, Fiona. I'm Claire. I'm the Senior Employment Advisor, and there's, I think, 5 of us from the team of Employment Advisors at Brighton Hove Wellbeing Service. So we're, all our clients at Mind have got some mental health, identify with some mental health difficulties. The employment advice team in particular, or we work just alongside that NHS primary care service. So everyone is probably experiencing anxiety and or depression. That's, de facto our clients come in that group. And there's a couple of people from the open access advice and information service here as well, who obviously get inquiries. And their clients could be anybody. Anyone can ring that sort of open access line. So the employment advisors do one-to-one casework with both job seekers and job retention situations. And I think we're quite often is sort of in the questions that we sent you, I think, helping people kind of work out, is this something they should be seeking an employment solicitor about, what the sort of thresholds of evidence are. We quite often work with people who feel that they've been very unfairly treated, but we're not sure, you know, quite what would constitute a legal challenge or not. So we do quite a lot of sort of liaison and negotiation about possible reasonable adjustments, and you know, hopefully before people get to the point of a legal challenge. But I suppose it's when it's getting beyond that sort of soft support, so that we can give people, you know, accurate advice and signposting. You know, we're not legally trained, so we're always aware of our limits, really. I don't know if there's anything from Muna or Corinne to add, the kind of questions that you're getting in your team.
I have actually got quite, you were really good actually, your organisation, you put lots of questions in.
Sent you lots of questions, yeah.
So that's lovely.
Thank you.
Thank you. And Southdown? Have you got any reps from Southdown?
Yeah, I'm Darren Hobden. I'm our Southdown, we're Southdown, we're not Southdown Housing now, we're a charity, and our employment services are funding jointly with the local county councils in the areas we work from and NHS England. We work on an IPS evidence-based model where we work embedded in secondary care mental health. So we're embedded in the mental health team within nurses, psychiatrists and occupational therapists, and we have people referred to us as part of someone's recovery and care plan. If they want to go to work, we're sort of there as a referral to work alongside the clinician to support an individual to get back to work, even if it's from an hour a week to 40 hours a week. We also deal with retention, which I'm quite passionate about. So I've done a lot of work with that over the years, over the 14 years in this game. So I've learned a lot and worked with a lot of employers, you know, regarding RAT plans and stuff like that as well. But and also working with people who are on section within the hospital. So we would visit the Department of Psychiatry, and so would my colleagues locally, to work with people who may be off work, signed off and in hospital, and not aware how to really approach work with that and disclose. And also people who also want to find work whilst in hospital. So we build up a relationship with the client at their, you could argue, lowest stage, just to give them hope, so to speak, if they want it and if they're ready to talk about it. Yeah,
that's great. Thank you. I didn't know that about your services at all. So that's really, really useful, really interesting, actually. Carers, we've got carers. Is anyone here?
Good morning, Fiona. Good morning, everybody. My name's Steve Castellari. I'm from the Carers Centre for Brighton and Hove. I think maybe it was mentioned at the start, Carers UK, but we're not part of Carers UK. We're a separate charity. We do work with Carers UK, so there might be a little bit of crossover there. I'm here primarily because I'm the engagement lead for the Carers Centre, but I'm also the working carers and employers engagement lead. So I go out and I speak to employers specifically about any working carers that they may have within their staff. And by working carer, we're not talking about professional carers. We're not talking about people in care homes. We're talking about family and friend carers, unpaid carers. I run a monthly group for working carers that want to return to work, or carers that are looking to create their own employment. And one of the things that sort of occurred to me is that there may be a number of carers who are caring for somebody who has a disability, and potentially there could be discrimination from an employer, which might be secondary discrimination, if that's the legal term, where the carer is being discriminated against because they're caring for somebody with a disability. Does that make sense?
I think, I mean, the reason that I was interested in you attending is that there's something called associative discrimination, where someone is discriminated against because of they're caring for someone that's disabled.
Yeah.
So I think I'll try and cover some of those issues as well. So, but you will also have unpaid carers in work who are also disabled.
Yes.
So it's and lastly, so someone from the NHS, I think, is here. Don't worry if they're not. Maybe the email address was to do with a joint service. So, okay, that's great. That's really, really helpful. I think, one of the things is that I think everyone's finding is that there's been a real rise in mental health issues, particularly, even if people didn't have mental health problems before the pandemic, many people have acquired them because of so many different issues. If life is difficult, then being in lockdowns, caring for people, struggling with your own mental health issues with perhaps a lot less support than you did have prior to the pandemic, has meant that many people who've previously coped have not coped. And certainly what we've seen is when redundancies have been carried out, that some of the first to go have been people with disabilities. There's lots of employers that can't be bothered to make reasonable adjustments. They find it a real pain. Lots of employers don't understand mental health issues. They don't understand that everybody's different and that some people get a better playing card at the beginning of their lives. That means that maybe they're more resilient than people that have been struggling with lots of issues since they were born. So I think that lots of services are overwhelmed actually at the moment. And whereas we used to do a lot of pregnancy and maternity discrimination, by far the biggest type of discrimination that we deal with at the moment is disability. So Chris, can I have the first slide? So if I'm sort of telling you everything that you know, don't worry, but as lawyers, good lawyers always go back to basics. We never forget the basics, and you're always, when you're dealing with cases, going back to whether someone's disabled or not, because quite often we're dealing with people that are likely to be disabled, but they might not meet one of the actual criteria, such as they might not have been ill for a year, but actually the test is likely to be ill for a year, not the actual year. So the reason why this is important is because there's actually a duty to make reasonable adjustments. It's good practice for an employer to be making lots of adjustments before someone does become disabled. And that's what we try and encourage employers to do in any case, because it's really important to keep people in work. So, the certain conditions are covered without having to go through these tests. They're just automatically deemed. So that's cancer, HIV, multiple sclerosis. And the statutory test is that they have a disability, if it's physical or mental impairment, the impairment has a substantially adverse, long term, so that's has lasted a year or is likely to last a year. And it's on their ability to carry out normal day-to-day activities, not what they do at work, but many of those things are day-to-day activities. So when we're talking about things like mental health, we're talking about concentration, the ability to sleep, all those things that are very, very important can be disrupted. So next slide, please. And I've just sort of broken it down. So, is there a physical or mental impairment? Does that have an effect on their ability? Is it a substantial, and is the substantial effect long term? This is why, it always needs to be applied. So if we just use dyslexia as an example, there may be some people that have mild dyslexia who will not come under this test, but other people who are word blind and very, very disabled by their dyslexia who will. And that's why it's really important. The problem with disability discrimination is it's become our most technical area of discrimination law. Employers are given lots and lots of opportunities to defend. They may argue things like they weren't disabled at the relevant time, particularly with depression. And so you have to be really aware of all these very technical defences that are raised. It's really unfortunate because really disability discrimination law was meant to, give a level playing field, and in fact, they are the hardest cases to fight. So for all of you that are doing this area of work, not only is it heartbreaking and very, very difficult emotionally sometimes to deal with some of your clients, but it's also very, very technical. So next slide, please, Chris. So there's lots and lots of different types of disability, but one of the main things that you need is knowledge. And I think this is where some of the questions did come in, actually. But it's not just actual knowledge, it's whether they ought to have known or should have known. I think there are some questions here about disclosure. I've dealt with some very unfortunate cases where employers have disciplined people for not disclosing that they're disabled. And I would think that that is absolutely, not all right. We now have better law because you're not meant to, as an employer, ask job applicants about their health until after you've offered them the job. Now, that's really important because I've now got a fighting chance of winning those cases for people who are not yet employees because they've been offered a job and the only thing that's changed is their disclosure. So I have a really, really good chance of showing that the test is on the balance of probabilities. It's, more likely than not, 51%. Well, look, someone's got a job offer and that's the only thing that's changed. I think they're going to have to pay up. So that one bit of, was quite a recent change, really 5 or 6 years ago, is, I think, really, really important for, people who want to get back into work. And it's fair. Obviously, job applicants, you should, as good practice, ask if anyone needs reasonable adjustments. But I can really see why, people really do not want to disclose anything about their mental health as a job applicant, because the chances are they just won't get that job. Pros and cons. I think that, once they get the job, disclosure is important because, reasonable adjustments might be needed. But again, it may be that someone is, has spent sort of 20 years suffering from depression, but coming in and out of that, sometimes very well controlled with medication, and sometimes not. And this is the other important point about the tests that you apply, that, substantially adverse effect on day-to-day activities. You treat them as how they would be without the medication. So again, epilepsy is a good example that without medication, someone might be fitting a lot, but they have very good medication, but they're still disabled because it's how they would be without that medication. Same with antidepressants. Next slide, please, Chris. So I'm going to start with failure to make reasonable adjustments because I think this is one of the most important for those of you that are dealing with retention, going back to work. Reasonable adjustments are really, really important. And I think the thing about reasonable adjustments, they should be thought about in a really practical way, starting with, the employer being asked what they think would help them, and then considering it. And in most cases, employers can't just say no. They've got to at least try it, and if it doesn't work, then say they can't do it. But it's any provision, criteria, or practice. It could be about physical features. I mean, that's when we're talking about wheelchairs and people that have difficulty with mobility. But most of them are about other things, such as graduated returns to work, shorter hours, although no requirement to pay full-time wages if people are working part-time. That is unless they've got full contractual sick pay. So, keep on this slide. So the Equality Act gives some really good guidance on matters where there might be reasonable adjustments. It's not easy for an employer to say no. Can we go to the next slide? So obviously the richer an organisation is, the more well-resourced, the more reasonable adjustments they will be required to make. And certainly even with small firms, then they will be at least required to try and not just say, no, this is impossible. So, you know, it's always good looking at the Equality and Human Rights Commission Employment Code set out lots of examples. I would also say that ACAS's written materials are very, very good as a free resource. They're written in plain English, they're not legal jargon. They're very informative. However, please do not take legal advice from ACAS conciliators. They are not legally trained. We end up in the employment tribunal all the time with employers and employees saying, oh, well, I did what ACAS told me to do. And quite often it's wrong. But everything that is written, all their booklets, anything on their website is checked by barristers and solicitors, and it's absolutely always up to date. So do use their written materials. They're very, very good. So next slide, please. Chris. So these are the sorts of examples of reasonable adjustments that you can ask for. So obviously the graduated return to work, working from home, shorter working days or weeks, providing training or mentoring, written instructions rather than just verbal, changes to premises, and providing equipment. But also quite often you'll find that maybe the people that you deal with are coming to you because they're involved in a disciplinary or a capability process, and any policy that an employer has should be adjusted for people with disabilities if that would actually assist. Next slide, Chris. So, you know, quite often, one of the things that's always really important if you do deal with large employers and they're going to occupational health is to ask for the instruction letter that they sent, because, you know, really to do a good job, they should really be asking, you know, are they disabled within the meaning of the Act? Are there adjustments that could be made? And then hopefully that occupational health advisor will be talking to the person that you're dealing with and asking them for their thoughts. And it's always a management decision. So, you know, obviously they can be guided, but they might decide that some are appropriate and others not. But that's where grievances come in. I mean, if they're just, you know, half-heartedly picking up one or two of the recommendations, but not really the ones that are going to help, the formal grievance is really your biggest, you know, is the biggest thing in your toolbox, I would say. Employees, the only way that they can change things is to bring a formal grievance. And why informal grievances aren't very effective is because there doesn't have to be a beating. They haven't got the right to be represented, and they don't get a decision in writing that they can then appeal. Usually nothing happens. So I know that it's difficult, and obviously most grievance policies start with trying to talk to someone, which obviously you do, but you know, I think you have to move on very quickly to formal grievances. Next slide. And just a little bit about access to work. I mean, we've used them, they've been brilliant. We have quite a lot of people with hidden disabilities within our own firm. You have an assessment. If equipment is required, you do pay for it up front as an employer, but then you claim it back. And I think one of the problems is that a lot of employers don't know about this service. And I think if they did, they might have a different view. So we've always found them to be excellent. And, you know, the other thing is, I suppose, that if people with disabilities that have moved on from us, we've encouraged them to take all the adaptations with them. I mean, I think one of the sort of crimes about this wonderful scheme is that quite often you've got in council cupboards full of adapted equipment that didn't follow the employee. And why that would be the case, I don't know, because they're usually very, very tailor-made. So next slide, Chris. I suppose I don't want to bog you down in too much of the detail with the types of discrimination, because I think that in some ways being over technical can be problematic. Where it does become important is when you issue proceedings, because the first thing that a judge does at an employment tribunal is they do ask the person who might, if they've been doing it on their own, just put in a written statement that just says everything that happened to them, just as a factual statement, which is fine, no problem with that if it includes everything. But they then ask them to clarify what they consider to be direct, what's indirect, what's discrimination, and that's where it starts to get technical. So one of the questions asked is, you know, when do I involve a legal advisor? I mean, we offer free support to ESRA. Well, we offer a half-an-hour free interview, don't we, for people where you've got really stuck with and they just need help. That's what we've been offering through the Disability Matters campaign, a free half-an-hour for employers and employees. And I think that if we could service that, we would really try to. The aim of this training is to really make you confident, you know, confirm that what you're already doing is brilliant, or just give you some more help so that you can really, really deal with these people up to the point that a lawyer might want to take over. So one of the resources that we have on our website is a template grievance. And in my opinion, the most important thing that you ever do is the help that you give someone who may have learning difficulties, who may be so stressed and anxious that they actually can't put a chronology together. Because my experience of dealing with people in that situation is that very, very high-powered executives absolutely go to pieces and can't do anything, can't do chronology, grammar. The story is quite difficult when you're overwhelmed. And so people that have access to organisations such as yours, or good friends, or, you know, friends that are HR, this putting together of the story is the most important thing. It doesn't have to be technical. It doesn't have to say what's direct, what's arising from. It just needs to tell the story. And I suppose from your point of view, what you just need to be saying is, I believe, you know, when they're talking in the first person, I believe that I have been treated less favourably because of my disability, and they might be then comparing their treatment with someone else. It can arise from disability. So there is a defence to that, which is that the treatment is a proportionate means of achieving a legitimate aim. But it's not an easy defence for any employer. Indirect is where you're applying provision that puts a group of disabled people at a disadvantage. Again, they've got to show it's a proportionate measure giving a legitimate aim. Next slide, Chris. And then we have victimisation and harassment. I have to say that there are quite a few people that come to us that are borderline, that may not, you know, it's questionable whether they are in the disabled sort of camp because of the test being quite strict. But certainly by the time that, you know, this person's raised a grievance and is asking for adjustments, lo and behold, they get sick of them and they victimise them. And then we have an absolutely brilliant case. And it doesn't matter that maybe the things that they were raising weren't absolutely correct in law. The fact is that if they then, you know, are clearly disabled, because, you know, a lot of the time it's likely to be, we're just not sure yet. Not everybody's had depression for years. They might be suffering from depression for the very first time. Then victimisation is where they're treated less favourably because they've complained or intend to complain, or because they've given evidence in relation to another person's complaint about disability discrimination. So quite often, most cases that I deal with, there aren't witnesses, there aren't people brave enough to come forward. It is always the employee and their version of events. You don't have to have lots of people supporting someone, you just have to have their story. And I think someone's saying, you know, when does it become a point in law? I think I always say to my clients, really, you know, if you've got a gut feeling that you're being treated this way because of something, I mean, we deal with all types. They're usually right, actually, because sometimes discrimination isn't really, really overt. Occasionally it is, but it's usually more subtle than that. And of course, there's harassment as well. So what I haven't included on here is associative discrimination. The sort of most famous case about that was where it was a law firm. Law firms are traditionally terrible employers, and most of our really important case law is all about employees bringing cases against lawyers and their law firms. But I think she was a secretary and she had a disabled daughter, and she was harassed because of caring for her daughter. I would say that in the pandemic, we've done more associative disability discrimination cases than ever before, because we've had people shielding, you know, elderly people with disabilities that they've lived with, and they're being penalised and treated a lot less differently than people that have had issues around childcare. And we've used that as the comparator. Someone with caring responsibilities with young children compared to someone looking after someone that's disabled. So that, you know, we didn't see a lot of those cases before, but they have become more and more common. Next slide, Chris. Is someone asking a question? Sorry. Perhaps that's just feedback. Sorry. So grievances. So if it's not possible to resolve a grievance for informing that, I mean, that would be, you know, that person talking to their manager or someone in HR, formal grievance in writing, setting out, you know, really what's happened. Quite a lot of people sort of try and make them really short and bullet point or make it into a list. I think as humans, we read novels, don't we? And we like a story that we can understand. And I think when you're preparing a grievance, you should think, well, you know, if I was the person hearing this and I didn't know any of the people involved, would I really understand what's going on? That means they can often be quite long, because they might have to put quite a bit of history in. I think they need to be in chronological order, and I think they need to always name, when you first mention someone, it will be their full name and their job title. Because you've got to remember that if it ever goes to an employment tribunal, they don't know who these managers are or whether it's the line manager. So that's a sort of test. I mean, and you know, when I help someone prepare a grievance, I go back to it and I read it and I quite often think, oh, blimey, you know, if someone reads this, if they don't think that this is an awful state of affairs, you know, what sort of a person are they? So, you know, it's a story, and I suppose the thing is about people that are often overwhelmed and there's been lots and lots of things going on, they might prioritise something that really isn't as important. But I think it's good to get everything down there, because then someone more objective can perhaps edit it a bit. But quite often our grievances are long that we help people with, because I say to them, well, look, if you don't tell us about it, we won't know. So let's get everything down. And I can't stress to you how therapeutic fighting and raising grievances is for the person involved. This is everybody. This is not just people with mental health problems. But there is something about someone that is a bit broken, having someone on their side who listens to them and helps them build their case, that can really, really, really affect people's mental health in a positive way. And we see this all the time. So the grievance process is really important for all those reasons for you as reps, but they're very time consuming. Where people have got, you know, you can do checks on funding. So that was another question. Legal expenses is usually found on people's home contents insurance. It's occasionally on buildings. It's occasionally on people who have super duper bank accounts. So, I mean, the problem is when you're dealing with people that are very affluent, a lot of people don't have home insurance. You know, they don't have all singing or dancing bank accounts that put a nice legal expense insurance policy, but it's always worth a check, because although, you know, it varies what sort of advice you're going to get, people do have the right, if they've got disabilities, to reasonable adjustments with a legal expense insurer. So quite often we can persuade the legal expense insurer as a reasonable adjustment to let us have us, because we're a specialist. And quite often we'll argue, yeah, I know your policy says that you should only get assistance at the point you're issuing proceedings, but as a reasonable adjustment, this grievance is going to be really important. I want you to fund the grievance. And we do succeed in that. So, you know, we do quite a lot of legal expense insurance. We know a lot about that. Very good about getting on board as solicitors of choice. I helped set up legal expense units for SAGA and AA, so I know a lot about legal expense insurance. And, you know, quite often, if it's being blocked, because of course the insurer wants them to use a panel solicitor because they just get paid £1,000 per case. Whereas if they come to a solicitor of choice, we get an hourly rate. But you know, you're more likely to get a solicitor and not a paralegal. And as I say, you know, they can be tricky. So next bit about grievances. Next slide, Chris.
Fiona, just to let you know, Claire has raised her hand on the.
Right, okay, Claire. Yeah.
Just to say, I think we certainly the clients we work with, and say they all do have some mental health thing going on, and often feel overwhelmed. We've had lots of people who are very reluctant to raise a formal grievance, and they fear that it's an incredibly stressful process.
I cannot tell you how stressful it is for anybody to raise a formal grievance. They're meant to be the way that an employee has their say. But it's one of the most stressful things that anyone can do. And if you've got mental health problems anyway, the thing is that a grievance is a tool, and invariably a good grievance will result in a settlement agreement or a COP3, where actually if the employer is absolutely determined that they don't want them, but they have discriminated, then what we do is we go in quickly, we negotiate, and we try and get money for the injury to feeling. The beauty about disability discrimination is people don't have to resign and claim constructive unfair dismissal to bring a claim. You can have someone that's been discriminated against, who is off on sick leave, and you issue while they're still employed, which is obviously very uncomfortable for the employer, but they're not losing their income if they're on contractual sick pay. They're not losing their job. They're not having to resign with immediate effect. The thing that you have to be really careful about as advisors, and this goes for trade union reps as well, is that the time limit is 3 months minus a day from the act of discrimination, unless it's a continuing act. You can't hang around for grievances, appeals. It doesn't get delayed. The only sort of thing that you have with people that are very ill is that if they miss deadlines, you can apply to go in late if it's equitable and just to do so. And tribunal judges are very, very, where there's really good reason why someone couldn't lodge within 3 months minus a day. In most disability discrimination claims, there will be continuing acts. So as long as they're all linked together, you're looking at the last act. But this is why, you know, you can't hang around. I know that, you know, one of the things about bringing a grievance is that you can ask for it to be heard on paper only. That could be a reasonable adjustment. So where it's absolutely brilliant and everything's set out, you can say, my client is far too frail, and as a reasonable adjustment, I want this to be done on the paper. Well, it gets sent to a solicitor anyway, invariably, if you're at that point where you've got a really serious disability discrimination claim. Why put your client through it? You know, they can put their questions in writing. We often do this where people just can't cope. And obviously there is a duty to make reasonable adjustments, and that is to any grievance process, any disciplinary process, to any capability process. I think employers are remarkably blasé about that duty. And, you know, judges have been doing this for a long time. They really get a sense of a workplace, its culture. You know, they're not stupid. You know, they get a lot of cases. So, you know, these sorts of things can help make a grievance more bearable. But I suppose, you know, what you have to be careful about is if you are supporting through someone through discrimination, that, you know, like you're saying, it's the signposting, isn't it? It's just being aware, knowing what you don't know as well, and getting them to the right person. I mean, any person that rings off, all their details are taken by a front of staff, and they will invariably have at least a 15-minute call where we discuss, and we do that with reps as well. So if you did that with your client there, we could signpost you through. And I suppose the other thing is we do offer no win, no fees, which is quite rare. They're damage-based agreements, and we usually take 35%, including VAT. Usually we have to charge people for an assessment, but if we've been working with people on a case and we can see that people, you know, and we've just got the grievance and the response, it may be that we can just say, oh, just read that. You know, we're not dealing with a case we've got like boxes and boxes of paperwork that's going to take us 5 hours to work out whether there's, you know, a good chance of winning or not. So, you know, the prep is the grievance really is the story. The grievance really gets converted into the, you know, the claim, because it doesn't have to be really technical. It just has to be what happened. It can become technical afterwards when the judge asks, is that direct, is that indirect? I suppose it's just about being thorough and getting the whole story down there. So you've got your formal grievance, why it's important. They have to hold a meeting without unreasonable delay. You can ask for it to be virtual as well as a reasonable adjustment. Yeah, that's much easier for people to do a grievance on Zoom than it is face-to-face. And also it means you might be able to support them doing that. Note taking is really important. They should go in accompanied. And my experience of employers' notes of meetings are that they are poor, mainly because they don't like writing things down that make their organisation look bad. So they're quite often summaries when actually I want someone to go in and do them like a play. Because if you put the initials at the side, you don't end up spending ages going, and so-and-so said so, and you can more or less get down what people are saying. The person hearing the grievance should be as independent as possible, certainly not the investigator. You shouldn't have someone investigating and hearing. I see more and more HR being, you know, the people that hear the decision maker. That's not right. I mean, HR are there to investigate and guide managers. And I've even seen HR consultants come in from businesses. Well, that can be very expensive for small employers, because actually then they're taken to a tribunal. They'll have to pay that HR consultant to come and attend court and justify their decision. I have to say, I mean, this is probably pretty awful, but I don't think the quality of advice of HR consultants and knowledge is particularly good. I think even in our councils and our educational institutions, it's particularly poor. Some of it incompetence, some of it willful avoiding of reasonable adjustments. I particularly see teachers in this town treated particularly badly who've got disabilities. And so, you know, good employment advice is important, but, you know, many of you with your experience, I would think, have a very, very good grasp of some of the employment law issues. And I think, you know, what I probably would like to do as a community law firm is to make sure that you are as skilled as possible so that you can be as supportive as possible. I think certainly around my community engagement, that would be very rewarding. So next slide, please.
I shall. I'm just saying Darren has also actually got his hand up right now.
Right. Hi, Darren.
I'll make it quick. Just to clarify on something, when it comes to a tribunal, is someone with a bona fide disability that's covered bringing a claim, do they because the law changed, didn't it, about how long someone can be working with a company before bringing a tribunal against a dismissal.
It doesn't apply to any type of discrimination. Someone who attends an interview who's not even employed, if they are not selected for the job or shortlisted for a final interview or offered the job and then withdrawn when they disclose their disability status, they have a discrimination claim. There is no service requirement of 2 years for any type of discrimination. And therefore, that means that applicants for jobs who are not even employed yet, potential employees, have the rights to bring claims. Just because you've got a disability doesn't mean you've got a claim. You know, what you're looking at is, you know, have they been treated less favourably or unfavourably because of their disability? Have they asked for reasonable adjustments that haven't even been tried out? And has there been a failure? Because failure to make reasonable adjustments is direct disability discrimination. You know, all these things, you know, indirect is less common, but can be used to write things where someone might be expected to meet a criteria that stops them getting promoted. I'm trying to, most of our cases at the moment, if I give you examples, they're cases where, so unfair selection for redundancy, they're almost picked out because they've got a disability.
Does that include their sick time off? When it comes to redundancy?
If anyone has, I don't like Bradford scores, all those employers that do Bradford scores, I think they're rubbish because you're not allowed to count any time that's disability related.
Offset.
So that can't go in.
Okay.
Yeah. You can't use, if someone's got a disability, you can't use any of their sickness time as a criteria for selection. Yeah. It's usually much more subtle than that. It's usually that they, when I ask them, I say, who else is being made redundant? Actually, there isn't anyone else but them. And then I ask them what's been going on recently, and they said, well, actually my anxiety has been such that when everyone else has returned to work, but I really don't feel that I can, and I've asked as a reasonable adjustment that I can stay at home, and they're really keen. And then lo and behold, there's a restructure, their job doesn't exist anymore, and it's just them. So it's usually, you know, more subtle than, you know, them telling someone it's because of their disability. It's just that they're disabled and they're suddenly the only person in the framework for redundancy. The other ones have been people disciplined for things where actually, if they'd made a reasonable adjustment to the disciplinary process, they probably would have made a decision not to discipline at all. So we've got one with Ezra where there's been some health and safety breaches that were probably totally to do with the disability and anxiety. A final written warning was given, which he didn't appeal because he's so frightened of losing his job, even though he got advice from Ezra to appeal. And then there's been another health and safety breach. And even though that they knew an organisation was on board, they weren't prepared to make a reasonable adjustment and reconsider the decision. They called him to a meeting and they've dismissed for misconduct on notice. So it's not gross misconduct. That's a really strong case, really strong. And he's worked there many years. I think the injury to feeling will easily be about 20,000, let alone the loss of earnings. So, you know, some of these cases are worth a lot of money, particularly to your client base, you know, because, you know, that's sort of like, I mean, the only problems. Can I just finish this?
Yeah, go on.
Before that I tell you this. The other issue is that you will get in, you know, the problem is that if people are on universal credit, they're only allowed to keep 6,000 without their benefits being doctored if they get any compensation claims. But with injury to feeling, we can set up a trust so that we can protect that and not have it affect their benefits, which is even more important that when we settle cases, the majority of the money is coming from the injury to feeling award. That's always the case anyway with people that don't get paid very much.
And if a case is won and the person is paid out, can the employee, is there a determination that that person can go back and work in that job?
I mean, they're very rare. It's very rare that you have. So when someone's dismissed, so like this case, for example, if that person doesn't want to be reinstated, they shouldn't appeal the decision, they should grieve. And that is because if you appeal, you have to be reinstated. And in most cases, that's not a good idea, because what we quite often see is where someone's being dismissed, they give them a final written warning instead, they get them back, and then they get them for the next little thing. So we're usually advising our clients, I know that you want to go back, I know that you've been there 13 years, but actually these people have treated you really badly. They seem to be very cynical. I think you should grieve instead. People are then grieving. Yes, you can get orders for reinstatement. They're very, very rare. I've only once had one of my clients reinstated, and that was where he had Asperger's, and the person that happened to deal with him at appeal, he grieved and it wasn't upheld, but it went to an appeal. And lucky for us, it was a really fantastic person who was very involved with Scope, and they upheld, and there was a sister company that they could put him into, rather than him going back to a workplace where he was actually being mocked by and bullied by his...
It's a big shame, isn't it? Because the employer or the work people in that environment will never learn then, and only do it to someone else.
The thing is, I'm afraid that where you really teach employers a lesson is through the purse strings. When an employer has to pay £30,000 in compensation, I think they usually will take steps not to be in that position again. So I strongly believe that financial awards are very good at deterring employers.
It hits home. Hits the pocket, yeah.
But do remember, a lot of employers are inadvertently discriminating. It's to do with their HR perhaps not being competent, or a lack of HR, so that they're including perhaps sickness, which is disability related. I think a lot of one of the things that we're seeing, for example, Ezra, as a way of financing their organisation, do the mental first aiders. I mean, it is good that employers bring in trainers. The example was given to me when I had someone in many years ago to do some resilience training with my staff, is that, when someone breaks their leg, quite often the employer will send out a bunch of flowers, and a card from everybody. But if someone goes off because they're very, very depressed and very ill, there's just complete silence. It's difficult because, of course, people, because of stigma, don't want people to know. But it really made me think, as an employer, the difference in terms of how we treat people with physical disabilities and mental health disabilities. So all that training that can go on, I'd love to see tribunals, as part of it, not only say that you have to pay this compensation, but you have to have mental health first aid training for you and all your workforce. That would be great. The next slide, Chris, please.
Okay, yeah, just to flag up, I've got two further questions.
Right, just get me on the next slide so I can see where we're going with this.
Got it, no problem. Here's the next slide.
Next question. Who's the next question from?
Karina's next.
Thank you.
Right, Karina.
I actually have kind of two questions that are linked.
Yep.
Can you hear me okay?
Yeah.
So is it possible, if an employee couldn't think of any reasonable adjustments, the employer has asked what would support you at work, and the employee didn't know, couldn't come up with any examples, the employer therefore didn't put any reasonable adjustments in place, but now later on, about maybe 6 months, a year down the line, the employee is thinking, actually, now that I understand how things are working for me and what could trigger my episodes of mental ill health, I have some suggestion, but I am on a final warning now.
I think the thing is with this is that if someone that has a disability, there's a duty to make reasonable adjustments. If you're dealing with somebody in the grievance, you can list what adjustments might help.
Okay.
Certainly, if an employee has been disciplined, maybe unfairly, I think they need to raise a grievance that has a background, which is everything that happened up until the disciplinary, the failure to make adjustments. It's not down to an employee to have to know what adjustments they need. It's an obligation, a management decision. I suppose it's like this thing, if you're dealing with lots of people and you know that there's someone in your team with Asperger's, for example, but they perhaps don't know that they've got Asperger's, but that leads to some quite difficult problems with, say, colleagues around flexibility, maybe anger and behavioural control issues. Then it's not down to the person that doesn't even know that they've got Asperger's to say that they've got the right to this. But if sort of somewhere along the line that person then perhaps gets a diagnosis, they start to look at a disciplinary offence they got that they're pretty sure is to do with these behaviours that they have, there is nothing wrong with then raising a grievance about that. And also the accusation being the allegation. I was involved in a disciplinary where it was clear that I had a disability. Reasonable adjustments could have been made to that disciplinary policy, so I didn't get a final written warning. In fact, I shouldn't have got more than a first written warning, given the way that my mental health issues would have impacted on that situation. Does that cover sort of what,
Yeah.
reasonable adjustments, any if you have a very good equality, an equal opportunities policy, so most firms have equal ops, some have equality and diversity, which goes further and says all the proactive things they should be doing. So I do always say that when you deal with people, you should try and get, and it's a workplace, you should get hold of their equal ops. And maybe the first, the bit that needs to be in the grievance or the informal grievances, your policy says that you make adjustments and that you train all your managers on dealing with disabilities. You don't do any of that. Lots of employers have got policies that no one ever reads and no one ever trains anyone on. And they are very useful in terms of looking at and putting in the grievance, because that's what, if they can't even follow their own policy, clearly they're in breach. But the things that are in the policy set out things that are statutory obligations. There's a statutory right to reasonable adjustments, for example. What was your other question?
So the employee may not have any idea of what reasonable adjustments may have at the time could have been helpful, but the occupational health department may have repeatedly recommended that the employer does not pursue the capability process as a reasonable adjustment.
That, you see, that's gold,
Right.
Most occupational health advisors say it's usually where someone's sort of having trouble with managers, until this conflict is resolved, this person won't be able to return to work because usually they're on long-term sick leave. I mean, obviously if occupational health have advised it, it's still a management issue, but what they've got to do is consider it, and if they don't do that, then you should grieve about it. It says on this occupational health report that you should not be going down a capability process at this time. I am actually going to deal with capability processes.
Oh, okay, sorry.
So I can go in more detail. Shall I just continue? Because I think maybe if we save some of the questions at the end, it may be that some of your questions get dealt with, and then I can just try and deal with those. Grievances, just as a working thing, ACAS codes of practice on disciplinary and grievance, they've also got a very long guidance. If you read those, I mean, great, bedtime reading, but they are very, very good, plain speaking examples of what is okay in terms of a grievance and how it's handled, and lots and lots of practical examples that deal with postponements and ill health and reasonable adjustments. So really would recommend reading those, because even as lawyers, we go back to them. I mean, that's the thing about being a good lawyer. You're always going back to basics. You're always going back to your Equality Act test. And if you're dealing with a grievance, you go back to your codes and your guidance, because those are the things that tell you how things should or shouldn't be done. Next slide, Chris. Right to be accompanied works on a statutory right. So quite often people aren't in trade unions, but if they have, they can have a rep. But what I do find is lots of reps don't take any notes, which, you know, I've offered to get, I used to be at Thompson's, I was a trade union lawyer for many, many years, have offered free training to trade unions. It's really important that those people that go along do take a good set of notes, because often we're working with notes that aren't correct. Disabled workers are entitled to reasonable adjustments, and so quite often we ask that they might be accompanied by a friend or a member or the organisation that's helping them. I mean, unless that friend or member of the family is a lawyer, an employment lawyer, and would be, or they're known to be really difficult to them, they should really agree to that. And certainly, you know, I work with employers as well. It's very important that grievances happen, that people have a fair hearing, and I encourage employers to allow, even if they haven't got disabilities, if they don't meet the level of long-term, but they're just someone that's very anxious, better that they deal with a grievance or a capability process, making adjustments so that that person feels that it's more neutral and supportive, so that you can, you know, get on with it and deal with it fairly. Next slide. So if they're not available, which often trade union reps aren't, then the employer must postpone and come up with a reasonable timeline. Again, you know, reasonable adjustments is that your client might need additional time to prepare for a disciplinary or a capability process. So you can ask as a reasonable adjustment that they have more time. And the companion has the right to address the hearing. So they can, you know, what I usually say is they can ask questions. If I'm dealing with someone that has a member of their family that can help them, we usually put together about 5 or 6 questions. And pertinent ones quite often are, did you consider making any reasonable adjustments to this process? Do you know that I'm disabled? Did you think of instructing occupational health to advise on reasonable adjustments? All the things that are really important, you can have the rep ask the questions at the end of the case, and also submit them and ask them to be in the written grievance response. They usually don't do it, but I mean, the fact is that they probably don't want to answer a lot of those questions. So, you know, the companion can ask questions on their behalf. They just shouldn't answer questions on behalf of the person. It's for them to answer questions that are being asked. Next slide. So, you know, things that this happens a lot where, you know, the person is just too stressed and ill. So you can get the meeting rearranged, but do have a think about asking, if it's a really good grievance and all the facts are there, ask about just having it dealt with on paper only, and then asking your client for written responses to questions which you can then help them with. You know, that makes a grievance process bearable if someone is just so fearful of the confrontation, really. Most people don't like confrontation. You know, it's, and particularly if they're upset about how they're being treated, they're, you know, they're worried about crying or breaking down, you know, because again, you know, this whole thing, you know, of looking capable, I suppose. And employers, you know, the thing about adjustments, there should be, you know, if someone's upset, an adjournment, or if they're better in the, you know, in the mornings, making sure that you don't have a meeting in the afternoon, rest breaks, someone else to, you know, come as the person to accompany. All those things can really help a grievance be manageable. So I've just lost a lot of people on camera. What time is it? It's 11:07. Is everybody all right to continue? It's just because there's such a lot to get through. I could do a rest break. Is that okay? So next slide. We can make these slides available as well. So
there's a message in the chat. I'm just going to check. Oh, that's a yes, please to continue. Okay, sorry about that.
right, okay.
Right.
Okay, so the employer then has to decide what action to take. Sometimes at a grievance things come up and they need to go and make more investigations. And usually an employer adjourns the decision making process. But, you know, sometimes it's delivered and you'll want that decision in writing. You're entitled to that decision. And of course, the person's got the right to appeal. I mean, usually there's a time limit for that. As I've said before, you know, a reasonable adjustment might be asking for more time to appeal, and also making the point that actually, my client's not going to appeal; they're going to grieve instead, because actually we're going to go to employment tribunal. There's no way that he could return to this workplace because trust and confidence has completely broken down. I mean, why would someone who's been completely treated badly ever want to work in that workplace, and would it be safe for them to do so? You know, sometimes I just see such cynical behaviour that I wouldn't want my client to be exposed to, you know, changing a dismissal to a final written warning and then just lined up for something else. I mean, particularly, there are clients at the moment that are probably on the verge of sort of suicide. I mean, that sounds extreme, but I know that Ezra's dealing with many clients that are really, really being treated badly. And even though we point out to HR that disciplining them is causing them to have to go to hospital, that they're suicidal, they don't seem to have any understanding of just how harmful actions can be to someone that is right on the edge. And this is where the mental health first aid is really important. I don't know if these people never ever experience mental health issues within their own family or themselves. I don't really understand, because there seems to be a whole lack of human compassion. But, you know, quite often, you know, the type of work that you do, you can be dealing with people that really, really have just had so much happen to them, because some of your clients might not just have employment issues, they might have housing problems and, you know, problems with caring for other people, and there's been a pandemic, you know, and just one thing after another, where just something at work can tip them right over the edge. And, you know, we do tell HR exactly that, you know, I want you to appreciate what's going on for my client. Do you know what? Psychiatrists and community health teams are so supportive. They really are, because quite often, particularly when they work with people long term, they get attached, just like GPs, you know, are pretty on side most of the time, not always. So it's really important to, you know, speak out, and where you can see your client really struggling, tell them, because that will be produced at an employment tribunal, and it's absolutely relevant to the size of the injury to feeling award. You know, if you're being told that your client's in hospital because they're on watch because they might commit suicide, and then the employer goes on and ignores you and dismisses, there can be aggravated damages because you've actually told them that, and there's proof that they knew that and they still went ahead. Next slide. So appeals should be heard without unreasonable delay unless you need a reasonable adjustment, should be impartial, so it should be someone more senior who's not been previously involved. Certainly in small businesses, quite often it might be the same person, there's no choice because there's just one person that owns the company. There might be a sole trader. Again, workers or employees have the right to be accompanied. Reasonable adjustments again, and the outcome of appeal must be communicated in writing. I just want to tell you a little bit about employees and workers, okay, because discrimination law applies to workers as well as employees. A worker is someone that provides services, okay, personally. Now, any worker that's doing that, not able to substitute someone else, not a bookkeeper that's dealing with you as a client so that you are just one of many clients. Workers have rights. They have the rights not to be discriminated against. They have the right to holiday pay and all those things under the working time regulations. So sometimes you will have someone that says, well, you know, I'm self-employed, you know, I invoice. But if you just sort of, you know, sometimes actually they might not be self-employed, they might be an employee anyway. But if they are, you know, a cleaner and they have to give their services personally and they can't refuse the work and then get someone else to do it in their place, they will be a worker and they do have the right not to be discriminated against. Next slide, please. So this is about capability processes, which I think is quite common. So the thing about capability is that lots of employers get it wrong because they don't have a separate capability or performance policy. They just use their disciplinary process. So, you know, quite how it should start is an employer saying, you know, it's come to my attention that this isn't right, and I'd like, you know, I think I might need to put you on a performance improvement plan. But they should then say, what have you got to say? Now, if someone's saying, well, actually, it's not me, I don't have enough resources, I'm not managed properly, I'm not trained. Or if they're saying, actually, I've been really ill recently, I've been struggling with my anxiety, and actually, I need some reasonable adjustments, then to then go ahead without doing that first would be, again, a failure to make reasonable adjustments and also an unfair process. So the reasonable adjustments should be made to the performance improvement process, but also there should be a good look at it and an understanding that before putting them on a performance improvement, that they should really sort out the reasonable adjustments. So if they're very anxious, they can't concentrate, they're likely to come within the ambit of the Equality Act, then they probably need things such as their workload reducing. They may even need to take some time off to gather themselves. All sorts of things before then putting them on a PIP. And any agreed targets should be realistic and achievable, and they should include the support that the employee has asked for. Next slide, Chris. So stress, anxiety or depression have contributed. A reasonable adjustment might be asking the employer to suspend the disciplinary capability in order to investigate further and to get the assistance that they should have. So that might halt the PIP. Certainly, in my mind, that if someone raises a grievance, if I was advising an employer, I would be advising them to deal with a grievance before disciplining or putting them on the capability, so that all those issues are resolved before that step is taken. Something that happens quite a lot is that, and it can be frustrating as well, that where someone's trying to manage someone, they go off sick. And I think it's fine for someone to have a week or 2 weeks to collect themselves. But if you're working with someone, the problem is if they don't then follow up the grievance or you know, start getting involved with saying why the capability process is unfair and they need more support, that it all becomes overwhelming. And I think it's very important to let people take some sick time and use that time to start writing their own grievance. Because if you're working full time, it's very difficult to at the same time get all your thoughts on paper. So, but then after that, you know, GPs really should be filling in fit notes. So they not only say what people can't do, but also what they can do. And that might include not being able to work, but can attend a grievance hearing. So, you know, what you don't want is for everything to stall and then just all mount up. Next slide. So, I mean, quite often in people's robust contracts of employment, if they won't consent to a medical report, it could be grounds for a fair dismissal. So you should always check someone's contract. And very often when we're working with the employees, I really encourage them to be engaged with the whole issue of going to occupational health. That is their opportunity to tell them exactly what's going on. If I'm acting for employers, I do actually tell them that they really should get GP notes, so that it's not just the person informing, self-reporting, but they also have the medical notes there. And if the medical notes are really helpful, you should have a think about, you know, maybe seeing if it would be a good thing to offer those to occupational health. They never these days go straight to the employer, they go straight to the occupational health advisor. And if they are being disciplined or on a capability process, you know, make sure that the outcome does take into effect all the mitigating factors, and that reasonable adjustments have been made, or, you know, some sort of mitigation, you know, so it's a less serious penalty. But these are often, if people are unfairly on capabilities or disciplinaries, even if their policy says that they can't grieve, if there's a disciplinary, I will get the client to grieve. So, and ACAS advice is that in most situations, it's better for an employer to deal with a grievance first before moving on. Because of course, if you ignore it and someone's saying you didn't make, you know, reasonable adjustments, they just don't deal with it, then there's a really strong case against them. Next slide. So there's also, I don't know if you deal with cases where ill health can be a fair reason for dismissal. This is not an easy dismissal by any extent. It's very hard. And employers have to have very good evidence. A recent medical report, it must be by someone that really has the expertise to provide a prognosis. I mean, if it's occupational health, they should have a background in mental health. You can ask for their CVs. And one would expect to see the employee dealing with an employer that is empathetic and understanding and compassionate. And unfortunately, we see the reverse in some cases, which, you know, is very difficult for the client. So next slide, please, Chris. So in order to dismiss fairly, they have to show that they're adequately informed, and that's why they must have the correct medical evidence to show that there's a prognosis that they can no longer do that job anymore. If you've got a very on board, helpful psychiatrist, they will always out-trump an occupational health advisor. With mental health conditions, the only person that's really allowed to diagnose, unless it's Asperger's, is a psychiatrist. It can be an educational psychologist, obviously, with Asperger's. And, you know, they do really have to show that it's the last possible resort. So next slide. So, you know, adequately informed also means the employers sought information from the employees to the effect the condition has upon them and adjustments. Perhaps got the medical notes to occupational health. You do have to get a proper consent, and usually no employer wants to hold, or, I mean, I don't know how you deal with very confidential information as a data controller, but usually you might want to have a look at those and then destroy them, but make sure that they go to the right medical expert. Sometimes you do have to look through them. But in most cases, I don't know. I know that on a case that we're working with where someone had very long-term anxiety issues, the one place she was going to was her community mental health nurse, so that she was saying about work was all in her medical notes, because they had to keep intervening and saying, please, could you stop changing her shifts like this? She needs continuity. What you're doing isn't really helpful. But I did get the notes because they were contemporaneous notes from an expert that absolutely supported everything that she said in her complaints, because she'd used her mental health nurse as a really good support, and they'd been the main intervener, in fact, on that case. So next slide. So yeah, you know, you've got to have a prognosis where they say this person, you know, is not likely to be able to do the job. You know, employers can continue with the process, and maybe in cases where there really is a situation with an ill health dismissal, which might be in your client's best interests, it can be done with reasonable adjustments and support. I mean, we all talk about people leaving with dignity, don't we? And certainly, you know, any person that's so ill that can no longer do their job and there's no suitable alternative employment, we want them to be dealt with kindness and support. Next slide. You know, there are situations, but they're very rare, where an employee could just go, and that would be where someone really wouldn't engage at all. I mean, someone asked, didn't they, about someone being sectioned? If someone is so unwell that they're sectioned, they're definitely going to come onto the, you know, they would be likely to be ill and have a substantially adverse effect on day-to-day activities for a year or more. I think even with someone with depression, because if we know, you know, one of the things that, you know, you would ask them is, you know, you're on medication. The reality is that most GPs would probably want someone to stay on antidepressants for at least a year. They're sticking classes, they're to help people cope. But I think as soon as you know that someone's got depression and that they've got antidepressants, they are going to meet the terms of your quality out, really. Yeah, this is the whole thing about, you know, a friendly psychiatrist. A medical report from a psychiatrist will cost about £2,000 easily, which is why quite often we're very reliant on national health doctors providing a short report on someone that they've been treating for a while, and a lot of them are really, really happy to do that. You know, it might take a while because of their resources, but they're very often wanting. I was very pleased with that Ezra case, Sarah, where I advised you to grieve, not to appeal, and then you went to the psychiatrist to see whether they could help and what they thought, and they said that they thought it would be more detrimental to his mental health not to fight, which I really liked, you know, because it is true that,
with an exclamation mark as well. Yeah, and it was really, yeah,
if you're victimized, then you feel like a victim, but if you're helped to fight for your rights, you get up off your knees. And, you know, I think we all try and work with people that are vulnerable in a way that's empowering, that gives them a voice, but that everybody in bad times needs at least one person on their side. And this is where I really see people who are quite broken and have lost a lot of self-esteem because they've been told they're not very good at their jobs, actually sort of go through a process and they go, oh yeah, you know, I was entitled to more help and that wasn't fair. And it's good to see, it really is. And it's the one thing that will probably help them get another job, because if someone's broken, it's really, really hard to then even get them into an interviewing situation because they're so lacking in confidence. So next slide, please. So before they're dismissed, you have to look at suitable alternative work, but of course in small workplaces, that often isn't available. And also they must look at reasonable adjustments before doing this. It has to be the very, very last resort. So next slide. So, you know, they must show that there was no training that could alleviate, they've sent a written statement, employee must be invited to attend the meeting, and they have got to be given the right to appeal that ill health dismissal. The next slide. So, you know, employers should have equal opportunities policies. I mean, they're damned if they do and they don't follow them, and they're damned if they don't have one at all. I think, you know, at tribunals, that's one of the first things that the judge asks. It's really important that people are inducted and know what's in their staff handbook, and that managers are trained in those policies. So, and employers may be liable for the actions of their employees and also third parties, contractors that they use. And the whole point of the grievances is that you're bringing to their attention that a colleague is being discriminatory, or a contractor. And then it's up to the employer to do something about that. Otherwise, they will be held vicariously liable for their employee or their contractor's actions. Next slide. And there's a common law duty to take reasonable care for the health and safety, so that would mean making reasonable adjustments. We do have some claims that are really personal injury claims. They're very rare because the case law is someone that's been really, really stressed, had a breakdown, gone off. There's been lots of recommendations of adjustments when they come back. They're not done, and then the person has a second breakdown. Now, it would be reasonably foreseeable that if someone had a breakdown and you didn't do those things that had been recommended, that would happen again. But that is a very high test for a personal injury claim, where one's saying that you know, they have suffered serious psychiatric damage because of the failure of the employer to take certain steps. This does get a bit complicated. I used to be a personal injury lawyer before I was an employment lawyer, so we do have cases where people have a disability discrimination claim where their disability has been exacerbated by the discrimination, and I will attach a personal injury claim to the disability discrimination claim. It's something that we specialise in, just because I was a clinical negligence lawyer as well for many years before doing employment, so I'm very comfortable with particularly medical issues, but I think the main thing is that we can only add a personal injury to a disability discrimination claim. So it's usually where someone has suffered from depression, and then a series of treatment has exacerbated that to the extent that they have been sectioned, and we can show a causational route that it was to do with the employer's actions. Usually it's more complicated than that, because I would say that normally there's a variety of issues. They might be home issues as well. But we do bring those claims, and we have won claims where really there hasn't been any personal issues, there haven't been any bereavements or other things going on. It has been solely down to the way that the employer has behaved. Next slide. Tactics. So things that I do think are very useful sometimes are subject access requests. I do have a subject access request letter, which is a precedent which I'm really happy to give you all. The reason that that's important is sometimes you know that there might be information that your client doesn't have. I wouldn't stop the grievance. I usually put a subject access request in at the same time as the grievance. And they've got 30 or 40 days to comply. A lot of them just don't, but then you can report them to the ombudsman anyway. But sometimes you do then get stuff, or it just is part of them actually thinking, do you know what, I want to settle this and offer a settlement agreement. I do think you should use lawyers to advise clients as to how much they're getting. I think trade unions do this, and they don't do their clients a service, because you need a proper employment lawyer who knows how much people will get in a tribunal, because otherwise you could really, really undervalue a claim that might be worth 40,000 and they just end up with 10. And for some of these people, they might not work again in reality. So it's really, really important. I mean, The real problem is that settlement agreements, there's a legal duty for them to have an independent lawyer and for them to advise, and they pay a financial contribution. What a lot of employers do is they use COT3s. They go to ACAS, and a COT3 will look exactly like a settlement agreement, but there's no legal obligation for it to be signed off for an independent solicitor. And what we normally do is, when people come with COT3s, there's no reason why an employer can't make the same contribution if it looks exactly the same as a settlement, and we ask for that. And quite often they will do it if they want it settled. We're more likely to get that where an employer is offering something really decent and the client doesn't really have any claims, or they're not very strong claims, because then obviously the solicitor looks at it, will be saying, do you know what, this is a good amount, I think you should take it. Less likely to offer it if they're offering £5 grand and they know it's really worth about 40 because they've had solicitors onto it. We've got a template on our website about how to raise a written grievance that you can use, and we've put the link in there. We're going to let you have these slides if you'd like them. People like stories, you know, in order. And the human element, you know, this happened to me and it made me feel like this. You know, it's just very important for the person hearing to be under no doubt about what's happened, when it happened, and then how it made that person feel. And dates are important. I mean, even if you just get someone to put in approximate dates, you know, you can't just say someone bullied me or someone discriminated against me. You've got to say exactly what happened, where, who might have witnessed it, and the words used, you know, because again, if someone's, you know, trying to deal with a grievance, they've got to be able to understand. And then if you're accusing someone else of having done that, actually present that to them so that they can actually put their version of events in. But I do see lots of grievances where it's not very clear what they mean by bullying, and that, I mean, that's no help. What they mean by discrimination, it's got to be lots of detail. But you know, if you can't get the exact date, if you even just the month, particularly where it's been happening for about 2 years, it can be really, really difficult. And obviously the most recent are more important, but it doesn't mean you don't have a background of all the things that happen, so that the person hearing the grievance understands why it was such a big thing that happened, because it's in the context of all this stuff over the last 2 years. Yeah, have a look at the Equal Opportunities Policy with its disability, and if they've failed to follow their own processes, put that in the grievance. Next slide. Always consider reasonable adjustments that could help your client in any situation, such as a disciplinary capability, then bringing a grievance. And email on behalf of your clients in writing, because if you've asked for a reasonable adjustment and then they don't do it, you've got the proof to show that, you know, that it's not been done verbally or on the telephone. They can't say that you didn't do that. You know, quite often they'll get difficult and say it's for the client to grieve, but you might want to just explain that you have to help them because they're not really in a fit state to do this all on their own. And also sometimes you have to make further grievances. So you might have grievances and then it be heard, but you might have to put other ones, particularly where there's then been victimisation because they've raised a complaint, or you've grieved, they'll upheld part of that, but they haven't then done those reasonable adjustments, those things that they said they were going to do. You're just going to have to put another one in, I'm afraid, and, you know, keep forcing the issue. Do check whether they have legal expense insurance, so home contents, bank, sometimes buildings. And if you're doing a lot of things, I mean, we will consider cases for no win, no fees. Usually take 35%, including VAT. The aim of a no win, no fee really is that it's about utilitarianism, really, because there'll be some, well, we never have cases that we don't do much work and then they settle, that will then fund all those that go on and on and on, and then we end up with an 8-day hearing that we have to do the advocacy. I'm afraid We deal with lots of opponents like Peninsula, like insurance schemes, where they don't actually settle cases till the day of the hearing. It's just how it works, particularly if they're paying the compensation, because while it's in their bank account, that's fine. And so they will pay at the last possible moment. But in other cases where the client has a normal lawyer, if they have decent lawyers and it's a strong case and you've presented a very good grievance, it will be that grievance on which they'll be providing legal advice to the employer as to whether to offer some compensation. So that's why it's really important that grievance is as strong as it possibly could be, because a really excellent grievance is going to get that case settled really quickly, where you've got a more sensible employer with sensible solicitors on board. So I think that's it. And then I can deal with, I can deal with all remaining questions now. So have we got, I can have a look on here as well, actually. So sickness, shall I just go through some of the questions that you asked and I'll just respond to them? So one of them, I think we've dealt with access to work. Informational sicknesses policies, can it be individually based? No. A sickness policy is a policy for everybody. And when I train employers, and I do a lot of work for Community Works, so I work for a lot of charities and not-for-profit organisations, I do advise that there's back to work meetings after even half a day of sickness. That's for all sorts of reasons. It's because you really have a sort of handle on what's going on for people, and because you have these conversations where you're saying, I understand that you've been very anxious and you've been off. Is there anything that I can do, that we can do as an organisation to support you? Really important.
So Fiona, Olivia has raised her hand, just to let you know.
Okay. Olivia?
Hello, sorry, I came to this meeting a little bit late because I was having some connection problems, so I missed some things that might have been really important for me to hear. But I have a question about, I'll keep this as concise as I can. I have a young client who faced gross misconduct allegations after a hearing. After a disciplinary hearing, he was dismissed, but with notice, for misconduct rather than gross misconduct.
Yeah.
To my mind, it's been ramped up and never should have proceeded in the way it did. He's intending to appeal, so I perceive that he may be subject to disability discrimination. Are you suggesting that at this stage he could raise a grievance rather than appeal?
Well, it depends. The problem with appealing is that he could be reinstated, and if they get legal advice that says, actually, you've done wrong here, a very cynical thing to do is substitute a final written warning and then just wait for him. Be really careful, so misconduct where someone's dismissed on notice, I take it that they're paid in lieu of notice, he's not working his notice.
That's right, yeah.
So your date for limitation dates for bringing a claim are 3 months minus a day, because where you actually pay in lieu of notice, the date it's only if they work their notice that it would be, the 2 or 3 months or month that they work. So we haven't touched on ACAS conciliation. A way of getting longer time limits is that you do enter your client's case in for ACAS conciliation, early conciliation. You have to do that to be able to bring a claim. But there's no point, when was he dismissed? What date?
Oh gosh, this was just last month. It was a very long, procedure.
Whenever your client is dismissed, you write the date down, and the first thing that you tell them is that they've got to do something about this within 3 months and a day, minus a day. And if it was a month ago, certainly by the second month, you should be entering this case into ACAS early conciliation to extend that deadline. Because what you don't want to do is for someone to lose their rights to bring claims. So if he doesn't want to be reinstated, then he should grieve. But you see, what often happens is that employers stall on doing things, and then people lose their deadlines. Just be aware that when the ACAS code was written on grievances, there's a bit of a grey area where they don't have to hear grievances from people that are no longer employees. If I have employer clients, I would always advise that whether or not they're still employed or not, they would hear that grievance, because much better to hear that out and understand what the issues are than to face an employment tribunal. But a lot of employers might not. But just by grieving, you're going through a process where maybe you might be able to get more information. But I mean, ACAS early conciliation is a very simple process. It really is just about contacting ACAS, giving them the details of the client, and they do ask you, you know, would you be prepared for this to enter conciliation, so that there is an opportunity for the employer to compensate. So I'd always say yes, but don't just go to ACAS conciliation straight away, because otherwise you won't get the benefit of the extension of time. You know, if they've got 3 months minus a day.
He's very proactive. So what he was told was that he needed to appeal very promptly with when he received the report.
It doesn't. I mean, he can change that anyway. He can write in now if he doesn't, and say, "I've just taken legal advice. I've decided I don't want this to be dealt with as an appeal. I would prefer it to be dealt with as a grievance, because trust and confidence is completely broken down, and I would not want to be reinstated."
So there's an alternative there to raise it as a grievance. So where then does the prospect of the ACAS early conciliation come in? That's what I'm not clear about.
The thing is, whether you're appealing or grieving, you mustn't lose your time limits. It's no excuse to say they're still waiting to hear my appeal, or they're still waiting to hear my grievance. If someone's dismissed and they've got potential claims for unfair dismissal and or discrimination, because, you know, we can win unfair as long as they've got 2 years served. You've got to have 2 years service for unfair dismissal, but no service. You don't have any service requirement for disability. So you need to be making a note of your timing limit, so 3 months, and make sure that it's not on a Sunday, because you wouldn't be looking to issue a case on a Saturday or Sunday. Or, perhaps make sure that you do enter ACAS conciliation sort of within 2 months. The whole point of grieving is that if he hasn't raised disability discrimination in the actual hearing, or the failure to make reasonable adjustments, that's your chance to do it there. I mean, we do look with lots of clients with learning disabilities. There's all sorts of reasons why people don't raise things. Usually a lack of, some people don't know they're disabled, you know? Or I sometimes deal with clients that have Asperger's who don't know they've got Asperger's. They're probably the most difficult, because I do have to actually sit them down and say that, you know, I'd like them to go for an assessment, and actually, you know, in my opinion, there is an issue of what's gone on in terms of their behaviour that is associated with autism. Yeah.
But the difference in raising a grievance is that, because we haven't been made aware.
The difference in raising a grievance is that you can't be reinstated without your permission.
He wouldn't wish to be. Yeah, he really wouldn't wish to be. There's too much damage done.
Exactly. So what you want to do is, I've taken legal advice and I want to turn my appeal into a grievance, because there is no way I could work for you any longer, but I want to grieve because I believe that you've discriminated against me because of my disability, and I'm going to bring a claim in the employment tribunal against you.
Because I wasn't even aware this was a route, to be honest, and our concern is the reputational damage that this has done him really unfairly. Our concern is for the future. He's a young man working in a particular sector that he wants to continue working in. The thing about
helping people is that you usually do ensure that they get a reference as well, because the law is that no employer has to give any reference whatsoever, but what they must give must be accurate and truly represent the skills, because they owe duties to a prospective employer as well. But the basic reference that just says this person was employed from this date to this day in this position is acceptable, even if someone's being dismissed for, you know, gross negligence, weird as that may sound. So, you know, making a fuss does usually end up in you being able to get a basic reference of somebody. ACAS run quite a few courses, you know, that are good. I don't know, I mean, the CA Stuart, who used to work for me, when he retired, was doing voluntary work at the CAB, Stuart Markless. I don't know if he's still in Brighton. He's an excellent lawyer and could be a good resource, but I mean, he left me 5 years ago, and maybe even he feels that actually retirement does mean retirement.
I mean, it may be that this client has access to legal funds because he is a homeowner. He will have household insurance.
We've mentioned
it may be that he's got funding he's not aware of.
We're going to let you all have the slides. You've got to offer every client that rings us up. We'll speak to our reception. They take basic details and they will get a phone call back from a lawyer who will give them good advice. And we can do all of that with you as reps there with your client if you think that would help.
And at that point, that's free of charge at that point?
No, I mean, we basically sort of advise what should be done. We give a cost estimate. We ask about legal expenses, and then we send in writing the cost estimate. If the client accepts, then they get a terms of engagement letter. We were heavily regulated, which they have to sign. We have to do a identity check because we are people that, you know, have to sort of regulate everything in terms of money laundering, ID fraud. And we usually ask for a payment on account. It's usually 500 plus VAT. But in some cases, we might be able to hop on to legal expenses straight away. And we try and work with people where we get them to do things. So what I normally would do, where someone tells me, you know, a terrible tale and they're being dismissed, or, you know, they're being discriminated, I say, you know, the more you do, the less you have to pay a lawyer. Could you draft me a grievance? Here is the template. Take your time, come back, because if you order your case and put all the facts together, I can just go straight to the law. Where it's really difficult, and the brilliant job a lot of reps do for us, is that the person's so stressed that they help them put the narrative together in order, because that's what takes a long time. So we try and work with people that are affordable, but some people just can't do that. But that's where you all come into play, really, because that's why we try and work with ESRA in a way that we're upskilling and giving precedence and working with people so that really you come to us just for legal advice, not for the bit where you're just putting the story together.
Okay.
And also, you know, if someone's got a strong case, we can offer no win, no fees. I was saying it's very rare because employment cases are really difficult because they're found on the facts, and if the judge doesn't like your client, it's easy for them not to win their cases. Some cases are just so overwhelmingly strong, like the one, Sarah, that you've had recently with the person that was dismissed, and will have a great psychiatrist report. I've more or less said that I'll offer him a no win, no fee, because I got involved at a point where I drafted a letter for Sarah to try and get the HR people to make adjustments, pointed out he was suicidal. It's all there, and they just ignored that. I've got a great case. You know, they're just. Have you had the dismissal in writing yet?
No, still hasn't received a decision.
No, I think that's because they've gone to their lawyers, and their lawyers have gone, oh my God, what on earth have you done? And so they've done it all verbally and told him he was dismissed, and a week and a half later he hasn't got it in writing. So it doesn't mean there hasn't been a dismissal, it's just that obviously they know they've done something wrong. So, you know, we try and be fair as well. I mean, if people have got savings, it's like gambling. We say, if you've got some savings, this is a strong case. You're better off, obviously, pay as you go, and let's see if we can settle it, you know, by doing up to a couple of grand's worth of work. But where we can see we've got really difficult opponents, you've got someone like Peninsula on board, you know, people need the security of knowing that even if it goes to a 5-day hearing, they've got us and then we'll be their advocates at the hearing. So, but we ask people to choose. I mean, I have to say that our no win, no fees just about balance out, because invariably we just don't happen to get, I mean, discrimination cases are not easy. And where we've got sort of more well-off people, they do take our advice and they finance, and quite often, if they're put in a really good grievance with our help, we'll get a really good settlement, and we get great out-of-court settlements. I mean, our preference would be to get someone their compensation sooner rather than later. Why go through the stress? But if it's an unreasonable employer or an incompetent HR advising them who doesn't seem to understand that they've done something wrong, you know, we have to wait until they get to a solicitor who probably has to put the pleadings in defence, who then will say, you know, you're going to lose this. You're much better paying up than paying us to defend you, and then losing anyway. Is that helpful?
I think so. I mean, could my client and me approach your firm for some preliminary advice?
Yes, I mean, could you do it, because we're so busy, we're a little, I mean, how many of us are there? I've got one person on maternity leave for a year now, my right-hand woman, but there's 4 of us. We are in the coronavirus. Quite a lot of my women have children, so they keep getting the coronavirus again and having to leave the office again. So, you know, the way that we keep everything in control is we have a really lovely front desk where people ring in and you can say, I'm Olivia from this organisation, with my client's this person. They'll ask for certain information that's really important, such as the date of dismissal. It's much easier if they do all that, because I can then prioritise which cases I go back to immediately. And then we try and do a phone call back, a lawyer, on the same day within 24 hours. But if someone says to us, oh, I'd really like my rep to be with us, we'll try and put it in the diary so that they're with someone that can perhaps take notes or really take in that sort of advice. We'll have a chat and we'll put in writing just you know, what our advice is and our cost estimate. And then if they want to proceed, we'll go on. But we can certainly give you that initial advice to signpost. And the thing is, by working that way, you'd really, really know what to do. You've only got to do one, and then you know next time for the next person. So, but I'm going to give people the slides. I've got a subject access request letter that I think would be useful for you all. I'm trying to think. Is there anything that you...
There was a template letter grievance, you said, didn't you? Or
it's a template on our website, so people go to it. There's a whole landing page on grievances and then a template where we say do a sort of background here, and people can work their way through. It's really useful. We found that really has helped, so that the quality of the grievances that we're getting from the potential client. So what I'll have told the client all the things, potential client, all the things I want your contract of employment, I want your equal arts, I want this. I want you to draft your own grievance, and then I get it all in one email. And then I can start work just putting the law in. And that means that they might have spent the weekend on that. They've saved themselves lots of money. And if the grievance, you know, some are better than others, I might have to do more work, but I track it for them. And I put in the bits of law. And then they're off to go. We're at the, you know, that grievance process. So, but, you know, some people just don't have any money. You know, it's as simple as that. So if we can help you, but then, you know, if we've been helping you and then they dismiss them anyway, it's a bit like on that case, I've just gone, I don't think I need to assess it. I'll do a no win, no fee if he wants it. So, and I also, when I work with people a long time, I trust them because I know that their skills are very good and they've got lots of experience, they know what they're doing. And if they say, oh God, this is a really strong case, Fiona, I know it is. So.
Fiona, I've got to go, I've got a 12 o'clock, but just wanted to say thank you. Yeah, that's been really, really inspiring. And I think to know what our role can be so we can kind of get it all ready to then hand to you is really, yeah, useful to know that even though we're not lawyers, we can have that impact and help someone tell their story. Yeah, so thank you. Yep, I've got a dash. Yep. Thank you so much.
Exactly that. You are
nice to meet you all. Yeah, yeah. Thank you. Bye.
Bye. So we have got to 11:58. So I'm happy to stay on a bit longer if there's any more questions, but if you will use your email address to send out the notes, that subject access request letter. And if, you know, I can do more training, I can do very individual training, which would just be on how to handle a grievance. You know, bite size is sometimes great because it's really, this was a lot to take on. Far too much, that's why I'm going to give you the slides. But I'm really happy if you as an organisation want me to come and just do a bite size. So anyway.
Fiona, Naomi has raised her hand.
Okay.
Oh, hello, Fiona. I'm not going to turn on my camera.
That's okay.
One difficulty I experience is when you can only get one side of the story. We can only hear our client's side of the story. And often we can't hear the employer's side of the story. Or perhaps we don't have all the detail, you know, from their HR or from their supervision notes. So the chronology we get is only one side of it. And that's where we have to be very careful in how we support and signpost.
I think Naomi, the thing is that's all I get as well. And the thing is,
yeah, I was wondering how you work with that.
Well, I mean, it's very rare that I sort of feel uncomfortable and I'm thinking, this doesn't ring true. Usually everything sort of follows a course. Sometimes I'll pick the phone up and have a conversation with HR because they've been usually when they've been offered a settlement agreement. And I'll just say, well, look, you know, this is what my client's saying. What have you got to say? And if there are things that don't quite match or where you've got someone who's misunderstood what's been said to them, they're usually more than happy to send through the minutes of the meetings that they've had. So that, you know, and to say, well, this is our side. So it's quite easy to sort that out. And I can usually tell as soon as I speak to someone, an employer, whether if they're very evasive and don't want to send me anything, there's a reason for that. But if I have someone that goes, oh, do you know what that, we've really tried with this person, they really misunderstand. Can I just send you everything? I can then have a read and then take it back to my client and say, look, this is what they're saying. So, yeah, I mean, you can pick up the phone to the employer and just say, you know, I'm advising my client to bring a grievance because they're saying this. We haven't got the notes of the meeting. Could you send those through? Obviously, every time you get notes from an employer, you must get your client to check them. And if they are not correct, you must get them amended because quite often they will omit things that don't make them look good, or they could be totally inaccurate. And sometimes you have clients you have to read them to because of learning difficulties. So, but I would say that in my sort of practice, it's very rare. I do sometimes feel uncomfortable and I will pick up a phone, and occasionally my sort of gut feeling is right. It's so occasional though. On the whole, my clients are giving quite a coherent, maybe quite jumbled story initially. But you see, chronology and someone helping them get in order will help to get the story right. Because sometimes what's being said is just confused because they're overwhelmed. So that's my experience anyway.
Thank you.
I think lots of people are leaving now. You're all giving up the will to. Shall I finish?
Can I ask just one more question, please?
Yes, you can.
In my line of work, I have to work, well, I don't have, I work with a lot of people who are currently on a section in hospital or have voluntarily gone in because they recognise that they need extra support with their ill health. What I understand is if someone's sectioned or voluntary go in, if someone's in work, is that accountable towards their sick record for being off work, or is it because this person's diagnosed, say, with, say, bipolar?
When you're saying accountable, do you mean that as if they're made redundant? I mean, the thing is...
No, does it go against them on their record of being off work sick if they're in hospital, say they got bipolar or schizophrenia, and it is them, it's part of them, it's who they are?
Darren, I think obviously it could end up with there being a potential ill health dismissal if they never are able to come back to work. But essentially, if you're an employer and you get a phone call to say that your employee's been sectioned, one would expect there to be kindness and empathy and a general inquiry. They should keep in touch with that person. Obviously, they're going to be disabled within the meaning of the Act and they need to make reasonable adjustments. And what they need to do is wait and see. I mean, some people go into hospital and are sectioned, and if they're put onto medication fairly early, quite often there might be people that stop taking their medication for one reason or another, and maybe they did need to change their medication, that they might be well enough to return to work on a graduated return within months. So that type of sickness is immediately a disability, and you should be advising them that they have the right to reasonable adjustments. You would need to check their contractual sick pay. I think that would be the first thing an advisor should do, because obviously if they don't have any contractual sick pay, they will just get statutory sick pay for 6 months. That's something that, you know, an employer can't claim back anymore. They used to be able to. And you should, you know, obviously if they are entitled to contractual sick pay, you should be helping them get their full pay. That's usually with statutory sick pay as well. Also, they will be accruing holiday.
Yeah.
So, you know,
I think what I've been worried about.
An employer can't just ring up and say, oh, as you're in hospital, you're sectioned, I'm going to dismiss you.
Yeah, no, what I kind of mean is we all have ailments over the year, don't we, where we might need time off work. Yeah. When you have a condition where you have to be put in hospital on top of having sick time off for a cough and a cold or corona or whatever.
Do you mean for the Bradford schools? Do you mean that an employer that says, I use the Bradford schools, and if you have more than 20 days, no, you can't use that time? But I don't know many employers that still use the Bradford schools. They're very old-fashioned. They don't work very well. I'm not a fan, and they're dangerous. Of course, you know, anything that's a disability should not be included in a Bradford school. So,
because some people, if they have a certain amount of time off, it sort of triggers a procedure with the company saying, "Well, you've had this many days off now."
Well, I mean, it might trigger if they were off work for 6 months, an ill health dismissal, but it shouldn't trigger any disciplinary for time taken off because their Bradford scores are high.
Yeah.
So, okay.
Yeah. That's it. So
it depends what process we're talking about.
Well, with the ill health,
you can't discipline someone for being ill.
No, but when you say about the ill health dismissal, sometimes
I've just done the slides on what they would need to do. They'd have to get a medical report with an up-to-date prognosis. When someone first goes into hospital, they're a long way off from a dismissal.
Yeah.
You know, but the appropriate things for a rep to be doing is making sure that that person's checking what contractual sick pay they're entitled to. You know, they're getting their statutory sick pay, they're accruing holiday, helping them stay in contact with HR or their managers so that they're giving a sort of a lowdown on what's happening, what treatment they're taking, so that you're keeping the employer informed. Okay.
I must say, I agree with you with the HR side of things, because I've been in a lot of meetings with employers and clients where the policy and procedures are being, you know, that is being rolled out. But it's not law, is it? Policy procedures. If it's accountable to your disability, there's adjustments on the policy and procedures, isn't there, that can be done?
I think you've always got to look to that equality and diversity or equal ops policy.
Yeah.
Any process that is there, then if someone has a disability, you can ask for reasonable adjustments to the process and the policy.
Yeah.
That might give more time to do something, not to do any disciplinary action because actually it was disability related sickness.
Yeah.
The reasonable adjustments apply to every single practice and procedure in an employment scenario. So.
And does a reasonable adjustment have to be as part of, they have to be come under the Equality Act with a certain diagnosis, or if it's like anxiety and it's not down under?
We don't have that. You just apply the test that I gave you. It has to be
right. Okay.
Mental impairment, long term, likely to last more than a year, substantial adverse effect on day-to-day activities.